first time the Supreme Court ever used the label takings clause was in Penn Central in 1978.
Right.
So there's a whole another story there. On regulatory takings, though, my most recent work is on why we should be calling them involuntary regulatory servitude.
I love it.
Because it mixes up the idea to say that somehow there should be a separate subcategory of takings. It is all about the government is taking a specific interest, much like you could sell it, right? A servitude. You could sell an easement. You could sell a covenant to someone else that said, I won't cut down the tree in my backyard. Your neighbor could come and get a agreement with you and get a servitude that says you'll never cut down the tree because they want the shade, even though you have the right to cut down the tree. They have to pay for that when they buy that little stick in the bundle overall. So what's happening when there's a regulation that accomplishes the same thing, placing a limitation on someone's property, is really creating a servitude, but it's doing so in a coercive manner, an involuntary manner. And so I believe that the better terminology of this should be for involuntary regulatory servitudes. It calls it for what it is, rather than some amorphous thing that allows the courts to somehow distinguish and say that a regulation is not actually affecting property rights if it's only diminishing value.